My name is Linda Noriega, President of California Domestic Water Company, and I welcome you to the American Association of Water Distribution and Management's Thought Leadership Lab video module series. AAWDM, pronounced AAWDM, is a 501c3 nonprofit formed to advance the educational pursuits of public water systems and related entities throughout the United States. In concert with Appalachian State University, California Association of Mutual Water Companies, otherwise known as CalMutuals, and our charter lab members, we offer salient and meaningful videos on emerging issues facing the water industry. AAWDM is assisted by a committee of technical subject matter experts who willingly volunteer their time and expertise to further the knowledge compendium of all public water systems. This module encapsulates the evolving legal theory of sexual harassment and the impact of the Me Too movement. As a water executive, I cannot overstate the importance of removing all types of harassment, sexual and otherwise, from the workplace. It is not only unacceptable and reprehensible, but it also negatively impacts a public water system's mission, legitimacy, and reputation. Ownership of this issue starts with leadership at the board and senior management level and must extend to all aspects of an entity's operations and culture. A zero-tolerance policy that is deliberatively designed and sanctioned by council and fastidiously implemented by all employees is required to ensure an environment of safety, respect, and acceptance. Our featured speaker is Gregory Rowland, who is a partner at Haight, a national law firm. Mr. Rowland is a public sector employment law specialist who works out of Haight's San Francisco offices. He will highlight an employer's legal duty to provide a harassment-free work environment and detail the escalation of sexual harassment litigation from the Me Too movement. Mr. Rowland will similarly underscore the importance of culture, training, discipline, and documentation as integral prevention and mitigation measures. We welcome you to visit AAWDM's website at www.aawdm.org for more details on the association's mission, initiatives, and services. AAWDM video modules are available to all public water systems, related entities, and supporting stakeholders. Utilization of any aspect of this video without the express written permission of AAWDM is strictly prohibited. As with any presentation, the opinions associated with this subject matter are those of the speaker and not AAWDM, its members, or supporters. Additional details on this topic, including reference materials and transcripts, are available on the AAWDM website. Thank you.
Thank you, Linda, for that wonderful introduction, and thanks to AAWDM for this unique opportunity. My name is Greg Rowland, and I've been practicing public sector law for over 25 years. I've prosecuted sex crimes as a deputy district attorney. I've represented state agencies as a deputy attorney general. I've defended school districts in sexual harassment claims as a general counsel. Most recently, I have been representing managers who've been accused of sexual harassment. But let me just say this is far more than a legal issue to me. I'm the father of 4 beautiful daughters in their teenage years. And if anything, practicing law or parenting has taught me anything, is that we have to evolve with the times. And the times are changing and the old ways aren't working. So that's why this presentation is a unique opportunity to identify the challenges we meet as public sector employers and find new and different ways to face them. We're in the new normal. In 1991, we sat transfixed and mesmerized by the Anita Hill Clarence Thomas hearings. We heard on television every night words like pubic hair on my coke or long dong silver echo through the hallowed halls of the Senate. Our attention was fixed on sexual harassment. American life was changed forever. We're at a similar watershed moment now. In 9/11, we had the new normal with regard to airport security and terrorism. Now we have a new normal with regard to sexual harassment. And whether you think it had to happen or it's an overcorrection, one thing is for certain: we have to confront it because we know it's coming. Traffic on the EEOC website has tripled since last fall, since the allegations regarding Harvey Weinstein. The EEOC Select Commission on Sexual Harassment has reconvened, and in light of budget cuts in every other form of our government, the EEOC has increased its budget $16 million this year to specifically confront sexual harassment. An interesting side note is that the claims in state and federal administrative agencies have remained static. That's likely because there's a 300-day statute of limitations period to file a claim. But we have significant anecdotal evidence that there's a vast uptick in reports to the human resources departments. And we know sexual harassment litigation and the specter of sexual harassment in the workplace is expensive. I just pulled these off of verdicts and settlements in the last week. $7.3 million, $1.74 million, $3.5 million. But what's important to note is this doesn't take into account the impact on workplace morale, productivity, legal fees regarding disciplinary actions. The costs are difficult to quantify, but we know they're astronomical. Lately, sexual harassment has come into our consciousness because of the Harvey Weinstein effect. 51 men, distinguished men, powerful men, have either resigned or been terminated for sexual harassment. My secretary likes comedians and thus the pictures. Earlier in the presentation, I asked, did this have to happen? And as the father of 4 beautiful children and another one, the answer is yes, it had to happen in order to refocus our consciousness on sexual harassment and to make sure that workplaces are safe for all employees all the time. But the men you saw on the slide previously are not indicative of the real challenges of sexual harassment. These were important men. They had morals clauses in their contracts and astronomical buyouts. I just read yesterday that Matt Lauer's wife got $20 million. I think she'll be okay. But the unfortunate truth is that sexual harassment and the problems are here to stay. Set aside that it's an evolutionary, historical, and sociological problem. But this slide identifies 2 reasons why sexual harassment is so prevalent. First of all, it's commonplace. A recent study shows that 51% of people surveyed have been involved in an office romance. I personally thought that number was low. By way of full disclosure, when I was a young prosecutor, I became involved in an office romance. We got married, and all these many years later, we are very, very happily divorced. But think about it. All but one of your lifetime relationships generally goes bad. It makes sense. The workplace is a melting pot. Everybody has similar interests, stresses, and proximity. It makes perfect sense that people would become involved in relationships. And the second thing is, it's not prohibited. Contrary to popular belief, it's not against the rules to have a relationship with a coworker. I posit that there's probably not a fishing off the company peer policy with your district. There are no anti-fraternization policies and very few anti-flirting policies. I recently had a case where a superior became involved in with a subordinate at a workplace. They told each other they were single. One was even telling the truth. So they became involved in this relationship. As you can imagine, the one with the attachment, there were some jealousy issues. The employer ended up getting all their mutual text messages. Now, I learned a lot about text messaging, but the gentleman was fully exonerated because he didn't do anything that was against any regulation or any law. But that makes it difficult to police sexual harassment in the workplace. Now, what are we going to do in response to these unfortunate truths? Legislators reflexively think it's a good idea to pass laws, and these laws are important and well-intentioned. New York has a proposed law to prevent taxpayer funds being used in settlements against individuals charged with sexual assault and harassment. It also proposes setting up an anonymous whistleblower process. Now, this makes sense. Certainly, we are put off by our taxpayer dollars used to pay settlements for people who are accused, if not proven, to be committing sexual harassment. But at the same time, what would that do to people who want to enter public service? Public servants generally make less money anyway. What would it do if they were having to pay their own legal bills with regard to allegations of sexual harassment? An anonymous whistleblower process makes sense because some people are very uncomfortable reporting sexual harassment or talking about their coworkers. But at the same time, it can lend itself to vindictive or false claims of harassment. California can't be far behind. We are generally on the vanguard of these issues. Other ideas to confront harassment has been eliminate non-disclosure agreements and eliminate arbitration provisions in employment contracts. Again, they make sense. We want to highlight and shine a light on bad behavior, but at the same time, it may make settlements more difficult and more cases will go to trial. We want to eliminate arbitration provisions. We have a similar dilemma. So the issue is, it's just not as easy as passing another law because we have plenty of laws on the books now. So the point I'm trying to make with the value of this presentation is, what did Harvey Weinstein and his 51 married men all have in common? Of course, they were all men. But they weren't, but for the congressmen and senators, they weren't public sector employees. They didn't have the same protections that public sector employees have by way of employment contracts and memorandum of understanding, MOUs. So here's a point I want to make in this presentation, is that the same due process protections, the idiosyncrasies of public law, that give us the power to deal with sexual harassment also make us more vulnerable to accusations of harassment. Let me say that again. The same due process protections that all of us have in dealing with harassment give us the power to address it and also make us more vulnerable. So that is why we have to eliminate the specter of harassment and deal with it as a risk management and personnel issue. Now, I'm going to talk about some of the laws pertaining to sexual harassment because as a lawyer, that's really all I bring to the table. And we were going to try to discuss the current laws in a different context. We don't want to talk about cartoonish depictions of people hitting on young women and balding men and with clip-on ties saying the wrong thing. Because sometimes studies have shown that those type of sexual harassment trainings do more harm than good. I have been giving and receiving sexual harassment trainings for the last 20 years, and sometimes people walk out of the trainings making more jokes than when they walked in. Hopefully it's not one of my trainings, but you see the point. And unfortunately, my anecdotal experience is backed up by hard data. A recent survey showed that 81% of American employees think that sexual harassment occurs in most workplaces. Yet 90% believe that it doesn't occur in their workplace. That's a significant disconnect. So what we're trying to do is address the disconnect in the context of public sector employees. Many of those surveyed weren't public sector employees, so they don't have the same tools at their disposal to deal with this insidious problem. So before we get into the laws, there's one simple rule. Lawyers don't like simple rules generally because if they were all that simple, we'd all be out of work. But you ask yourself, when you're observing conduct or statements, would you accept someone else saying that to your wife, daughter, mother, or grandfather, or mother, or conversely to your husband, father, son, or grandfather? We all know that it's not that simple. But if you ask yourself this question from the onset, it will start the process to consider whether the conduct or statements that you're hearing are crossing the line to actionable sexual harassment. Take a look at this definition of sexual harassment. It's pretty well accepted. And you can see it's far more nuanced than the simple rule from the previous slide. It is a lawyer's dream. Look at all the terminology that can be parsed, argued about, unwelcomed, explicit, implicit, basis, substantially. The very technical definition of sexual harassment is why sexual harassment litigation can be so ugly, so protracted, and so expensive. This is the legal framework for sexual harassment law. Most cases are rooted in Title VII of the Civil Rights Act of 1964, 42 U.S.C., and in California, protections against sexual harassment are rooted in the Fair Employment and Housing Act. California law is necessarily more expansive, more plaintiff-friendly, so the vast majority of cases are brought under California law. There's also prohibitions against sexual harassment in the Civil Code Section 51, the Education Code Section 212.5, and in 1983 of the Federal Code. I wasn't kidding. There are a lot of laws on the books. So now we are going to discuss certain legal theories under which harassment can be brought. And we're all familiar with quid pro quo. This for that. There are other ways to describe quid pro quo that propriety prevents at this point, but understand it this way. If you do something, you get something. If you don't do something, you lose something. And again, it has to be just the mere suggestion, the mere nuanced suggestion that there's a sexual component to it. Again, it's never as obvious as if you sleep with me, you'll get a promotion. It's oftentimes far more subtle. You might want to think about dressing differently. You're a good-looking person. Why don't you use what God gave you? Things of that nature are far more nuanced. And the employment action, there has to be an actual employment loss. But it doesn't have to be dramatic. It doesn't have to be demotion or termination. It can be as simple as not granting a vacation or getting a bad performance evaluation. Quid pro quo is the most insidious type of sexual harassment, and be careful about the statements you make, because the mere suggestion of something of a sexual nature can land you in complex civil litigation and perhaps even on the evening news. The other type of sexual harassment litigation is the hostile work environment. Take a look at that definition. There's two important things that we need to understand from this slide. The first is the definition of sex. People often view sexual harassment as a man and a woman flirting and going too far. But the code defines sex in California as any characteristic related to gender. So if you make a demeaning comment about pregnancy, childbirth, a medical condition related to gender, or LGBTQ status, that can be considered sexually based and therefore harassing. Now, I'm sure we've all heard the term severe and pervasive. It's associated with sexual harassment law. And sexual harassment in the Me Too movement is the title of this presentation. This is what's changing in the courtrooms throughout the country. The severe and pervasive standard is changing, and it makes perfect sense. The media attention, social media, have changed the viewpoints of judges as to what constitutes severe and pervasive conduct. Judges typically are middle-aged, upper-middle-class white men who learned about relationships between men and women in the 50s, 60s, and 70s. This is all changing. This is all changing. Having sexual harassment on the cover of Time magazine on multiple occasions have changed the severe and pervasive standards. So fewer cases are being dismissed on summary judgment. More cases are going to trial. More money is being spent. More workplace disruption. And more careers ended. This slide talks about the factors that a court looks at to determine whether conduct is severe and pervasive. The courts try to distinguish between mistakes, boorish behavior, and unlawful conduct. And these are the factors they look at: nature of the conduct, frequency, how long it went on. But the most important and usual defense is context. Now, I was representing a client in a pre-disciplinary hearing, and he kept saying to the hearing officer, "But you have to understand the context. You have to understand the context." Finally, the officer said, "Why do you think context is important here, sir?" And I spoke up and I said, "He doesn't think it's important. The California Court of Appeal thinks it's important." Now, I don't know how that went over with the hearing officer, but it just makes sense. The context of the statements and the conduct are important. What is offensive and unwelcome in an office environment may not be in a field environment or a construction site, or even vice versa. Context is important. And it's important for the Human Resources Department to understand this and take action accordingly. This slide is conduct that has historically been found to be severe or pervasive. A single incident of such conduct can be considered unwelcome. I'm sure crotch grabbing jumps out at you in the audience. That's made popular at ballparks throughout the United States of America, but it's important to note that this is it's not unusual to have this in the case. I had a case in the early 90s where I was representing a fire captain who grabbed his crotch and said, "Bite me." I'd spend an hour and a half in deposition asking the plaintiff whether the term "bite me" was a sexual overture. Now, understand that was in the early 90s, that was before Me Too, and that's when sexual harassment litigation was in its embryonic stages. But it does underscore a point that very basic human interaction can be parsed, examined, and it goes on forever. But clearly, none of this conduct on this slide can be tolerated or prescribed. This slide is more of a gray area. It talks about the type of conduct that can be considered severe and pervasive based on the factors from a few slides ago. Now, understand that sometimes it is, sometimes it isn't. Not all of this type of conduct is actionable sexual harassment. However, it all creates a problem. It all demands a human resources response. And it's never productive in the work environment. There are a number of acts there, but the one I want to focus on is stories. More and more often, we're seeing that sharing stories about one's sexual escapades in mixed company is being determined severe and pervasive and unwelcome conduct, even if the statements don't have anything to do with the people overhearing them, have nothing to do with the workplace. sharing stories about one's sexual life has been determined to be severe and pervasive conduct. So clearly, if you have the urge to share, resist that urge unless you're not in the workplace. Now the following slides are going to be a few of the types of pinups that I've accumulated during my career in public sector law. Now clearly, these pinups on cubicles are focused on one particular gender. But I use these to underscore an issue, that anybody can be the victim of sexual harassment, men or women both. My particular favorite is the second from the bottom on the middle slide. What do you do to get a man to do sit-ups? Put the remote control between his toes. Now, I'm not saying I condone this behavior, but I understand the sentiment. And the last one says, grow your own dope, plant a man. The important point here is that unwelcome conduct is judged from the perspective of the victim using a reasonable person standard. Let me say that again, the perspective of the victim using a reasonable person standard. So courts are put in this unenviable and almost impossible position of trying to determine whether somebody is overly sensitive. Again, that's part of the unique and difficult nature of sexual harassment litigation. This final side, the politically correct bachelor party, and the citation underneath, that is to highlight that sexually harassing behavior can occur outside the workplace and outside of work hours. Just because you're at the happy hour doesn't mean you can get away with it. I recently had a case where a gentleman got drunk at the office Christmas party. I realize how cliche that is. And he kissed coworkers on their foreheads. He's no longer employed. And the third legal theory under which sexual harassment can occur is retaliation. Retaliation is another form of discrimination related to sexual harassment. And it focuses more on the employer's response than the actual conduct. That's an employer taking action against somebody who has complained or participated in an investigation. And again, the retaliatory acts need not be dramatic. It can be as much as a denial of promotion or a negative performance evaluation. So the point here is to be very mindful if you're giving an adverse employment action or a disciplinary action to an employee who has complained. I'm not saying you can't do it. I'm saying be mindful. Affirmative defenses to sexual harassment. Now this is where the rubber meets the road in this presentation. As you can see, there are affirmative defenses for an employer to a hostile work environment claim if an employer exercises reasonable care to promptly correct the behavior, prompt remedial measures. And the complainant unreasonably doesn't take advantage of the opportunities provided by the employer to deal with the harassment at the workplace level. Now, initially, I wanted you to understand that the same protections you have in public sector law make us more vulnerable. This slide is to understand that this isn't easy. It's a delicate balancing between taking prompt remedial measures to address harassment immediately and still staying within the rubric of the MOU and the internal workplace disciplinary framework. Again, you're asking yourself, if I am too harsh on this employee, am I creating evidence of unwelcome, severe, and pervasive conduct? By the same nature, if I don't do enough, am I exposing the organization to liability? And the answer to both questions is yes. So from this point forward, we're going to talk about the internal mechanisms by which we can deal with harassment. And we're going to do it in the context of a case that I've recently handled. Now, understand that this really happened. This is not a conglomeration of events like the 8-year-old heroin addict. This really happened. And it underscores how important it is to address sexual harassment early, take proportional remedial measures to avoid unnecessary problems such as morale, workplace disruption, and so forth. Now, I had a client who was a senior manager in a public entity, human relations, actually. He had already announced his retirement. He developed a relationship with a young woman, but it wasn't a sexual relationship. They were friends. Their families did things together. They attended each other's children's recitals. They dined together. They exchanged PG pictures, and they texted with each other. Now, based on your understanding from this and other presentations, that probably doesn't rise to the level of actionable sexual harassment. Then the supervisor was forced to give her a very minor disciplinary action, a letter of concern. What do you think happened next? The very next day, she filed a claim for sexual harassment in the workplace. First thing that happened is my client was placed on paid administrative leave. Paid administrative leave has, again, come to the forefront in American society. We are hearing a lot about it in regard to coaches that are being placed on paid administrative leave. Urban Meyer, very recently at Ohio State University, was placed on paid administrative leave. And traditionally, paid administrative leave has been a workplace mechanism by which you remove somebody from the workplace while an investigation is ongoing so they don't interfere with the investigation or make the rest of their coworkers uncomfortable. But paid leave has morphed into a somewhat weaponized personnel practice where people are removed from the workplace simply because they're not liked, and even if there's not enough evidence to sustain disciplinary action. Traditionally, California courts have determined that it was not an adverse employment action because there was no money being lost. They were still getting paid. However, recently, 3 California Court of Appeal decisions have found that paid administrative leave is an adverse employment action. And it is a somewhat secretive practice because since it's a personnel action, people can't talk about it, and there's no budget entry for paid administrative leave. And in the public sector, there's a great stigma attached thereto. So my client was placed on paid administrative leave. He wasn't told why. He was removed from the workplace, and he was told he couldn't speak with anybody. He followed the directions, and he started getting text messages from his coworkers saying, "What's going on? Where are you?" And then he was told that the rumor was that he had been fired for committing sexual harassment. So the next thing that happened is that the employer conducted an investigation. Now, Mr. Graham has a training module. There's a number of different training modules on investigation. We do them. There are some suggestions on this slide to facilitate a proper investigation, but it's important to note that more litigation is focusing on the quality of the investigation and the quality of the investigator. It makes perfect sense. There's an investigation conducted. One party or the other does not like the outcome of the investigation, so the investigation is attacked. Methods, biases, follow-up, documentation. So if you are conducting a workplace investigation, or if you're hiring somebody to do it on the outside, please make sure it's tight. And Paul Harvey, those of us who are old enough to remember Paul Harvey, said, and then there's the rest of the story. Let's be honest with each other. If somebody pays an investigator is going to find something. That's what they're paid to do. And generally, they find what the person writing the check tells them to find. It's not unlike an expert witness. So if you're dealing with a workplace investigation, dot all your I's and cross all your T's, because it's subject to terrific scrutiny. Now, what do you think happened to my client? They conducted an investigation, and oddly enough, they found, yes, he exchanged text messages and pictures, and yes, they were friends, and yes, the adverse employment action, the disciplinary letter he provided her was completely warranted, and that he had no intention to make anybody feel unsafe or intimidated. Great, right? Wrong. The employer moved for discipline, moved for termination, based on every cause for discipline but sexual harassment. Understand that. Every cause for discipline but sexual harassment. They had a very strong sexual harassment policy, but he wasn't charged with that. This slide is the discipline article of the Metropolitan Water District of Southern California. It's a large water district, and the MOU is a good MOU. Most disciplinary action in water districts are governed by MOUs. And they set forth a framework for how to impose discipline on a public sector employee, the same employees that have the due process rights that we discussed earlier. And you can see from this slide that it incorporates, that it has to be for cause, it has to be for an enumerated cause, and the causes are set forth in Appendix A. It requires a corrective action plan, and it follows the principles of progressive discipline, that each time there's offending conduct, the punishment gets worse. And this is exactly what happened with my client. This particular MOU had 39 separate and distinct causes for discipline. It's very thorough, very nicely done. I pulled a few from the appendix that may or may not be related to conduct that can constitute sexual harassment. For instance, insubordination, harassing or threatening or intimidating behavior. Please understand that conduct that is approaching sexual harassment or may constitute sexual harassment, you can take disciplinary action against people without calling it disciplinary, without calling it sexual harassment. That's exactly what happened with my client. He was charged with immoral conduct, unprofessional conduct, and violations of regulations. So he asked for a Skelly hearing. A Skelly hearing is a term of art, and California public sector employees have the right to have their side of the story heard by a neutral party with the ability to change the proposed discipline before discipline is imposed. The officer has to be impartial, they can change the discipline, and they determine whether the conduct is appropriate. This is a wonderful opportunity for public sector employees to deal with sexual harassment at an early level, to formulate proportional responses to the conduct at an early stage, and then rely on the principles of progressive discipline thereafter. It takes the emotion and the personal nature of a charge of sexual harassment out of the equation, and lets an impartial person take a look at the facts and circumstances, the context. This is a codification of the Skelly process in the Metropolitan MOU. It talks about the rights that an employee has to make these statements. And again, it is a real opportunity for the employer, because you get to hear what they're going to say. You get to hear what their defense is going to be in a sexual harassment case. You get to memorialize their statements before they're changed during the course of litigation. And remember, the depending on whether there's a case brought or whether there's a labor grievance, you may either be supporting or rebutting what that employee says. So it's critical at the Skelly stage to memorialize what the employer says, what the employee says, I should say. Now, my client and I went to the Skelly hearing. He argued that the conduct was welcome. There was nothing that prevented him from doing that, and that none of the regulations for which he was charged had anything to do with discipline. What do you think happened? I don't know what the hearing officer found. We settled the case. But the point is, it should have never gotten that far. That case and previous cases have taught me that in the era of Me Too, the power to accuse is the power to damn. So that's why it is so important to come up with processes, procedures to prevent harassment at the early stage, because it is so costly and so insidious to a workplace's production. This is why it's critical to build a culture. There are some suggestions on this slide about how to build a culture that is intolerant of sexual harassment and builds an understanding and respectful environment for all employees. You can accept or reject any of these suggestions and adopt it to the culture of your particular district. But at the risk of sounding like Dr. Phil, it's important to have candid conversations, all stakeholders, sharing their experiences, their prejudices, their biases, their understandings. I'm suggesting getting labor and management, men and women, together in a trusting environment with no repercussions to discuss these issues. Come up with policies and procedures, not from the top down, but from the bottom up. Have them emerge organically from your employees so they have ownership and buy-in, and they're less likely to misunderstand or reflexively cry sexual harassment or reject the notion that sexual harassment has occurred. These are the 5 prongs of prevention: policy, reporting, remedial action, documentation, and publication. Now, it seems like a lot, but the idea here is there's always something we can do. There's always something we can improve on every day to create a safe and nurturing workplace for all employees. And if we do that, we'll keep our productivity high, our employees will be happy, and we'll keep our insurance rates low. Policy. These are components that should be in every policy. More components of a good sexual harassment policy will be discussed in subsequent slides. But it's important that you revisit your sexual harassment policy yearly. When a judge looks at an employer's harassment policy and it hasn't been revisited by the board since 1992, they don't believe that that's an environment that is mindful of sexual harassment. There's been a lot of discussion of zero tolerance. And zero tolerance is an often used concept. We use it for drugs, we use it for a number of things, and it's pretty basic. However, sometimes it can be misunderstood in the context of a personnel action. Zero tolerance does not necessarily mean that you fire somebody for a statement that may offend my mom. But it does mean that every instance, every observation of sexual harassment gets a prompt response. It's always addressed by human resources. That's what zero tolerance can mean. And again, I'm going to return to no retaliation. All policies should include terms that say that no reporting employee can suffer any sort of retaliation. Again, we're seeing so many retaliation cases, I can't underscore that principle enough. Reporting. The policy should encourage reporting, even over-reporting. I've suggested to some clients that they create a cause for disciplinary action for knowingly failing to report sexual harassment. Multiple reporting options. This is critical. And I'm sure you understand why. People may be uncomfortable reporting sexual harassment to their immediate supervisor. They may be uncomfortable reporting harassment to a subordinate of the accused harasser. It makes sense. It creates a welcoming environment that is intolerant of sexual harassment, but it has a dual purpose. You remember in a previous slide that one of the defenses to a hostile work environment claim is if the employee does not avail themselves of internal mechanisms. If you create multiple reporting options, you are also building an affirmative defense. And you'll see from this point forward in the presentation that protecting the organization from sexual harassment and good, solid human resources policies go hand in hand. They're not mutually exclusive. They work together. And the slide also said, do not forget technology. Again, this is a recognition of the Me Too movement. Back in 1991, Clarence Thomas and Anita Hill weren't walking around with computers in their pocket that were stronger than Apollo 11. Now we have smartphones. Accusers are being believed because they have photos. And as we hear, people are making videotapes or audio tapes. There are workplace cameras that capture this conduct. It's just evidence. Consider incorporating technology into your sexual harassment prevention policies. Remedial action. Again, do whatever you must to make sure that the same behavior doesn't occur again. Make it commensurate with the conduct. Remember the catch-22, the delicate balancing between doing too much and too little. This is why we do what we do in law offices and at Human Resources. It's not easy. There's always something you can do to address sexual harassment. Training. This is another thing courts are looking at. Whether the accused has received training, whether the organization provides training, and the content of the training, and the acumen of the trainer. These are all being looked at by courts in sexual harassment cases. So don't cut corners on these things. Have multiple levels of training for multiple levels of employees. Field employees, board members, supervisors. And periodic follow-up. This is something that is often neglected, but it can be invaluable. Periodic follow-up. Courts are going to look at whether you took steps to determine whether the prompt remedial measures you implemented were in fact effective. You don't just want to take some measure and let it lie and not know whether it's working. The other thing is, again, if there's a dual benefit. People are much less likely to sue people they think care. There are remarkable statistics in the area of medical malpractice where people don't necessarily sue doctors that are bad, they sue doctors they don't like. So follow up with all of your employees on all your sexual harassment actions and see if they're working, and show the employee that you care. Documentation. This is Human Resources 101. Mr. Graham has a training module about this. Document every meeting, every remedial action. Make sure they end up in the employee's personnel file so you can substantiate stronger discipline under the principles of progressive discipline. But there's another thing that documentation is helpful. When it comes to a contested proceeding, a hearing, a trial, finders of fact, they don't necessarily believe witnesses. They know witnesses are subject to workplace pressures, biases, profit motives. And for some reason, some of these people think that lawyers may have told them what to say. Although that's untrue, jurors believe documents. They're created in real time, before a dispute exists, and they can take them into the jury room with them. It's very important. The last component in documentation is considering relationship contracts. This is not altogether a new phenomenon. Some law firms created relationship contracts back in the early 90s. But with the advent of Me Too, people are, organizations, employers, public sector employers, are requiring their employees to report when they're in a consensual relationship with a coworker and when it ends. And I'm sure you understand the reasoning behind that from a sexual harassment employer point of view, that in the context of a relationship, things are different than in the context of a non-consensual relationship for the purposes of sexual harassment. I think it's very helpful because most of the relationships I've been in ended long before I even knew it. So reporting would have been very helpful. Publication. Again, this is an area where there is a melding of good personnel practices and sexual harassment defense. You should distribute your sexual harassment policy in as many ways as you possibly can. Post it in conspicuous areas, employee handbooks, employee policies, procedures, disciplinary context. Again, if you post these and make these things prevalent, you're creating a culture that is intolerant of harassment, and at the same time, you are creating an affirmative defense. If the employee is told on multiple occasions that they have recourse within the workplace and they don't avail themselves of them, that is an affirmative defense. Now, the one takeaway that I want is that we've thrown a lot at you here today, but the idea is that we can always get better. The idea is not just to follow best practices and react, but create and implement better practices as a team. Thank you.
We thank Mr. Rowland for a meaningful discussion on such an important topic. Without question, sexual harassment requires significant attention and resources from all public water systems. Leadership from the board and senior management is required to ensure a culture of inclusion, respect, and safety. The solution to sexual harassment is a zero-tolerance policy that is deliberatively designed and sanctioned by council and fastidiously implemented by all employees. Such an unbending commitment is necessary to effectively root out this reprehensible behavior. Thank you for watching the AAWDM video module on sexual harassment and the Me Too movement. These videos are available to all public water systems, related entities, and affiliated stakeholders. AAWDM is a proud sponsor of these modules and appreciates the support from HATE, Allied Public Risk, California Association of Mutual Water Companies, and Appalachian State University. We welcome you to visit AAWDM's website at www.AAWDM.org for more details on the association's mission, initiatives, and services. AAWDM video modules are available to all public water systems, related entities, and supporting stakeholders. Utilization of any aspect of this video without the express written permission of AAWDM is strictly prohibited. As with any presentation, The opinions associated with this subject matter are those of the speaker and not AAWDM, its members, or supporters. Additional details on this subject are available on the AAWDM website. Thank you.